What are the documents that make up a complete estate plan? When does each document get used? I'm Freeman Green. Let's talk about it. I have here on the board a diagram to help us understand the different estate planning documents and when they get used. Here's how I think of the documents. We have documents in place to help us plan for mental incapacity, which is any situation where you're alive but unable to act for yourself. And we have documents in place to plan for death. We have documents in place to plan for our financial affairs, things we own, and debts or things we owe. And we have documents in place to deal with our bodies and our health and medical decisions. So, if I put things up on a grid like this, here's where the different documents fall. First, you will note I have the trust listed as the first document, and I want to point out a trust is optional. You don't have to do a trust, but the rest of the documents, really, you want to have those in place to have a complete estate plan. So, if you become mentally incapacitated and you have a trust, anything owned by your trust will be handled by the trustee. Typically, while you are alive and able, you're the trustee, but if you are incapacitated, then your backup trustee that you've named to serve will then step in and handle the assets of the trust for you. And they can use those trust assets to do things like pay your bills. If you become incapacitated, you always want to have a durable power of attorney in place. What is a durable power of attorney? A power of attorney is a document that you use to give legal authority to someone else, and it allows them to act for you. So, if I've put a durable power of attorney in place and I've named you as my agent under the power of attorney, you could sign my name to documents and it would be as though I signed those documents, which is really handy for planning for mental incapacity. The word durable in the phrase here, durable power of attorney, means that that document endures through incapacity. It stays valid, even if I've lost mental capacity. At death, anything owned by a trust that you've created will pass in accordance with the terms of the trust. You always want to have a will in place, even if you have a trust in place. A will is a formal legal document that says where you want assets owned in your own name to go at your death. If you have a trust plan in place, your will is going to be a very simple will called a pour-over will. And we call it a pour-over will because it just names the trust as beneficiary. In other words, it pours over the assets to the trust. If you have a trust-based estate plan, the hope is that we never use your will, because if we use the will, it means there's been a probate. But we still do a will, even if you have a trust, and the will serves as a backup. So that if you do something like open up a bank account in the future and forget to put the bank account in the name of your trust and it doesn't have a beneficiary designation on it, that account would go through probate, and then at the end of the probate, your will cause that asset to go under the trust. And I put some provisions in the will to make that probate a little bit easier, a little bit less expensive. Also, if you have minor children, the will is where we put the guardian provisions. Who will be serving in the parental role for your minor children if you can't serve in that role? During incapacity to handle healthcare decisions, we have a document called the Advance Directive. The Advance Directive is really just like a power of attorney, but over medical decisions. And in my home state, the state of Oregon, we call this document an Advance Directive. Other states might call this a healthcare power of attorney. Sometimes they'll also refer to parts of this document as a living will. But in Oregon, we have just one document that deals with those things called an advance directive. The advance directive does two different things. First, the advance directive is like a power of attorney over medical decisions. It allows the person you've named to make medical decisions for you in the event that you can't make them for yourself. Second, the advance directive is used to give end-of-life instructions or to express wishes regarding things like life support and tube feeding in an end-of-life situation. Sometimes folks call it the pull-the-plug document. Also, if you are incapacitated, helpers that you've named to serve in your documents, they might need to talk to doctors or medical offices. There's a federal law called HIPAA that says that medical offices can't communicate with people unless you've said that they can. So I always have folks sign a document that we call the HIPAA waiver, and it names the people that can talk to doctors on your behalf. And we want all the people you've named to serve as helpers in these documents, we want them all named in the HIPAA to be authorized to talk to medical offices. Then finally here, if you have died, someone's going to need to make decisions about your body. And they'll need to have authority to deal with a funeral home, for example. The disposition of remains form would kick in at that point. This document is used to name a person to make decisions about your body, and it would allow them to make decisions about things like cremation or burial. If you have already expressed your wishes, or if you have done a prearranged funeral plan, this is the document that would allow someone to see those things through on your behalf and would give them the legal authority to do that. So, these are the documents that make up a complete estate plan. A trust is optional. You don't have to do a trust, but a trust can be very useful for avoiding probate and helping to organize more complicated estates. Just having these documents in place, though, isn't enough. You want to think about the assets that you own and how you own them, and you want to structure them to work correctly with your estate plan. So, often at the time you sign these documents, there will be other documents that you sign to help with that process. For example, if you own a home, you'll want to sign a deed that transfers ownership of your home to your trust. If you have bank accounts or retirement accounts, IRAs, 401ks, if you have life insurance, you'll want to make sure that those are either owned by the trust for some assets or other assets. You'll want to make sure they have a beneficiary designation in place that links those to the trust. And asset by asset, you want to make sure that everything you owned is either owned by your trust, if you have a trust plan, or that it has a beneficiary designation in place so that it will avoid probate. Those are the documents that make up a complete estate plan. And when I'm working with a client and we're doing a new estate plan, when they come in to sign documents with me and we look at that stack of documents, this is what is in that stack of documents. Thank you for watching. I hope that was helpful to you. If you think that video might be helpful to someone else, please feel free to share it with them. And if you think that our law office might be able to help you with trusts, probate, or estate planning, please feel free to contact us. Thank you.